responsibility of providing electricity as a social service. However, the reality is that governments cannot do it, especially developing countries. They don't have the financial capability to take on the provision of electricity as a social service. So what is the way forward? The way forward is for the sector to be privatized so that private companies can then invest and bring in capital into the sector, bring in capital and be able to take out, their investment after a long period of time. And again, that is why all of this speak to the reason why a power purchase agreement becomes very critical, because in an unbundled sector, you don't really have this agreement. You don't have power purchase agreement and the other industry agreements that are relevant, to the industry. It is in an unbundled sector where you have different, players coming into the into the into the into the space that you need power purchase agreements and a suite of other agreements, for them to be able to put in their investment and then ensure that they recover their returns, and provide for other provisions that will give comfort to investors to invest in the sector. All right, next slide, please. All right, so this slide just speaks to certain, when you are advising in a transaction as a practitioner, you need to be familiar with certain things that are important even before you start drafting an agreement. Because what you will often see is that you'll be giving investment advice, not just legal advice. If you are in a market like if you're in a developing market, when investors are coming, they will ask you for investment advice. And this slide just speaks to some of the things that inform investment decisions that that companies will make with respect to setting up a power plant. So the first thing is the power demand. First of all, what is the power demand? What is the so there is no time. I will have just briefly let me just highlight the measurement for power. So there is the power is purchased is measured. You purchase it in measurement. You build your power plants with a capacity for certain amount of power, and you supply it also based on certain measurements. The baseline of measurement is the watts, right? Unit of electricity is usually measured in watts. That's the base measurement. Now, 1,000 watts is 1 kilowatt. Then 1,000 kilowatts or 1 million watts is megawatts. So many times, power is for utility scale is measured in megawatts. And the question you would then ask is, for a country, for example, what is the power demand for the country? So, for example, in Nigeria, you will hear, maybe they will say that Nigeria needs maybe 30,000 megawatts of electricity, based on the demand, the demands in homes, the demand in small scale industries, the demands in hospitals, everywhere. The total demand for that power is 30,000 megawatts, for example. Meanwhile, the installed capacity, all the generating companies on ground, maybe you have an installed capacity of about 12,000 megawatts. So you can see that there's already a gap. This is a country that requires 30,000 megawatts, but the generating companies that are on ground can only generate 12,000 megawatts. But in fact, that 12,000 megawatts, it is only if they generate in full capacity. That's the installed capacity. More often than not, they don't generate up to their full capacity. And even when they generate up to capacity, there is the problem of wheeling it. A lot of electricity, is lost if there is no proper infrastructure for wheeling or transporting the electricity. So in a place like Nigeria, you hear that at the end of the day, the peak of, generation is maybe 4,000 megawatts, even though there is installed capacity of 12,000. And then it could go down to even 2,000 sometimes, and even less. Because even when they generate, sometimes to evacuate it is a problem. So the power demand, depending on what you want to do, you have to look at what is the demand for this country to be able to, make a policy decision on the kind of power projects or power plants that you need for a country. But that is at the level of country. If you go to, maybe off-grid power solutions, it could just be your estate, right? You have an estate. You need an electrician to measure the capacity of electricity that is required to service every house in that estate. Or let's say the Dangote refinery, they did an analysis of the capacity of power that is required to, service the Dangote refinery. And it was based on that that they now build a power plant, that can meet the demand for the power. So that is why power demand is critical before you even talk about, having a PPA. You need to have a view, a picture of the power that is required. The technology is also important. There are different ways to look at technology. Initially we talked about source of energy, that some are from renewable source, some from non-renewable sources. Some renewable sources are solar, others are hydro. All of them have their own peculiar technologies. You also have, technologies from different countries. Germany, you have Siemens there, they have their own technology. You go to China, they have their own technology for every power plant that you want. So you have to look at which technology you are going to be using for the power plant. You have to consider your budget. You have to consider your location. Let me pause and ask a question. Why is location important? I know we discussed it earlier. Can somebody just can somebody make a comment on location?
Sorry, I didn't get your question. Sorry. Can you repeat the question?
Okay, I think somebody has gotten the question. So I see somebody's hand up. Let me see whose hand is up. Yeah, I can't. Sorry.
Yes, it's
Franklin.
my hand. Yes, sir. Can I go on, please?
Yes, please go on.
Okay, you talked about how the location was important because of the source of the combustion fuel. Being that we use gas a lot, you say that it should be located now in the southwest region where it's easier to transport from the source to the plant itself. And I could extend to say that if we were considering renewable sources, for instance, dams, we definitely have to position that in places which have the natural infrastructure like the river and if it were sun, the solar part, we probably need to position that in areas which have good sun rays.
Thank you very much. Thank you very much. I think that captures it. And as simple as this is, you'll be surprised at some of the wrong policy decisions that were made by previous governments that led to significant losses because they went and built power plants at locations where there was no sufficient, fuel stock for that power plant. Yeah, so that's in summary. That's thanks for that feedback, and that you've captured it effectively. Thank you. So the only other thing I will mention under this slide is the elephant in the room, and this is why this is very critical for for all lawyers, commercial lawyers, to take note of. When, in terms of power projects, the IPPs, that's the producers, they don't usually have sufficient capital to finance, the power plant. They may have equity, they may bring in equity for maybe for project development, get their licenses, and to some extent get the land for the power plant. But when it comes to the real power plant, they rely on debts, a lot of debts, for them to be able to achieve financial close and proceed to build the power plant, except if the money is coming from government. And so therefore, when you are, as a lawyer, when you are reviewing a PPA, what makes your PPA, ultimately everything you'll be doing, you are having it at the back of your mind. How will lenders receive this document? Will lenders be happy? Will lenders be willing to give money on the basis of this power purchase agreement? And that's why sometimes you need to have knowledge of the industry. You need to have some financial knowledge, on financing in a bit, have knowledge, basic knowledge of all those sort of issues, so that when you are drafting or negotiating the agreement, you have that at the back of your mind. Because if you sign a PPA and lenders are not happy to put money to finance the project will not take off. So that's very critical. And even when you are negotiating, whether you are negotiating for whether you're on even if you are on the project developer side, you still need to reach to a point where you know that there are certain things that are very basic, that you know that I have to give in to this so that the agreement will be bankable, right? And if you are also the buyer, you should have that at the back of your mind. So that's very important. And many of the clauses that you come across, they are being done in a way that the bankers to make the agreement bankable. So that's the elephant in the room. When we come to the parties in a power purchase agreement, you typically see buyer and seller, or producer and off-taker, or generating company and distribution company. But the main elephant in the room that you will not see are the lenders. And the document needs to be bankable for lenders to put their money for the project. Next slide, please. So that brings us to the parties. The primary parties in a power purchase agreement are usually two. The seller, sometimes is referred to as the producer, or the IPP, or the generating company, or the project company. Then the other party is the buyer or the off-taker, or the bulk trader. These are the primary parties, the two parties. However, beside these parties, there are other secondary actors that are very critical to the power purchase agreement, even if they are not, in some jurisdictions, I think you have parties beyond the buyer and the seller. But in Nigeria, it's just the buyer and the seller. But you may have other agreements with other parties, and you may have, which we are going to see subsequently. And then more importantly, there are other, actors that are very important. Now I'll be highlighting them briefly. You have the government. Of course, you have to know that the government sets the policy, and sometimes they provide incentives, for investment. So the government is very critical. The government is also critical in terms of, some of the reforms lead to sale of assets, power assets that were initially held by government. So in the context of those kind of, transactions, maybe where you are selling, the government is very critical because the assets are held, you are buying from the government. The government is also critical because for major projects, you want certain guarantees from the government. You want certain protections from the government. Without those protections, the lenders will be unwilling to put their money. So for those that are familiar with the Azura Power Project, what made it successful is that the federal government gave a guarantee for the project. So it's one of the few IPP projects that were successful, that have been successful in Nigeria. So the government plays a critical role. You also have the regulator. In Nigeria, for example, the regulator for the power sector is the Nigerian Electricity Regulatory Commission. However, there has been a change, since last year. There is the 2023 amendment to the Constitution that allows for states to have electricity markets. The electricity market before last year has been centralized with a single regulator in Abuja. But you have the Constitution that now allows states to have their electricity markets, and there are a couple of states that have already taken advantage of that. So you have, I think, Lagos, Ekiti, Enugu, Ondo, I think maybe about 5 of them that have already taken advantage of the amendment to the Constitution, so that you have state regulators, right, different from the federal regulator for the electricity. So depending on where the investment is, I know regulatory advice is a lawyer's forte, it's your call. It's part of what you'll be advising. What are the licensing requirements? What are the obligations under the regulations? What are, all of that, a lawyer will need to advise on them. This is the next. So you have the transmission company. The transmission company is very critical too. The transmission company is the company or the utility that is able to transmit the power, the bulk power. So most off-takers rely on the transmission company, to be responsible for taking the power on their behalf and transporting it to their location. So the transmission company is very critical. We had mentioned the lenders. We had mentioned, then there are others. You have the EPC contractor. So the fact that I have a power purchase agreement doesn't mean that I can produce the power plant. So the producer will typically enter into an EPC contract, engineering, procurement, and construction contract for the power plant. We also have the plant operator. So sometimes even the operations of the plant, the owner of the plant may not be able to operate it, and will rely on a plant operator. So that's where you have agreements in that regard. Then you have the fuel supplier, and then ultimately the most important person in all of this arrangement is the customer or the end user, which include industries, households, schools, hospitals, factories, and whatnot. So these are all the players. You have the primary parties and you have the secondary actors in negotiating a power purchase agreement. Yes, let's go to the next slide. So the next slide, so in those secondary parties, I just gave an overview of the project agreement. So there are, apart from the power purchase agreement, there are these project agreements that, that provide the basis for some of the other secondary parties to be involved in the project. So you have, the first of it is an option agreement, a lease agreement, a concession agreement, share sale agreement, performance agreement, grid connection, interconnection agreement, fuel supply agreement, fuel transportation agreement, EPC contract, operations and management contract, long-term service agreement, loan agreement, vesting contracts, direct agreement, credit support agreement, and sovereign support agreement. So these are all, agreements that you will, so if you are going to be involved in a project, right, that is utility scale, you will find yourself negotiating a number of these agreements in addition to your power purchase agreement. And so therefore, as you are negotiating your power purchase agreement, you know that there are other agreements that will come to play in order for the power purchase agreement to be effective. And you have to have mastery of not just your power purchase agreement, but some of these agreements. Let me just mention a few of them. So the first one here is an option agreement. So option agreement is an agreement that gives you an option to purchase land. Let me give you an example. If you want to apply for a license, once you are generating power in a country like Nigeria, once you are generating power from 1 megawatts above, it becomes regulated, it becomes licensed. The generator that you buy in your house, in your homes, in offices, the ones you see in offices, because of their capacity, they are below the 1 megawatt capacity, right? Generator like iPass, for those in Nigeria, if you're familiar with iPass, my neighbor, it may just be 1 kilowatts or even 500 watts that generator can produce. You don't have regulations for that kind of system, right? If you are in an office complex, maybe that is 3-story, it may get to maybe 50 kilowatts or 150 kV. I don't know, 150 kVA of a generator. Still, so that would be a big diesel generator that will be making a lot of noise. Maybe in your school you have those huge, generators, but they haven't reached that threshold for regulations. They have to reach like from 1 megawatt. That's like 1,000 kilowatts of capacity for that to be subject to regulation. And why I say that is for you to now understand the kind of size that you are looking at. So if you are going to, let me give you an example. If you are going to have a power plant, a solar farm, right? You want to generate electricity from a solar farm that will generate 10 megawatts of electricity. For that, the space that you need. So imagine, for those of you that have solar panels in your houses, you can find out the capacity of those solar panels. Maybe if it covers your roof, it may just be 7 kilowatts, right? Or 10 kilowatts. Now imagine you are producing, and I said that you require 1,000 kilowatts to have 1 megawatt and 1 million watts to have 1 megawatt. So assuming you are producing 10 megawatts, you can imagine the kind of capacity that is generated and the space that you require for the power plant, for the solar farms to be situated. You need a lot, you need land mass. Now, you can get that land through outright allocation by the government or through a lease arrangement. But again, sometimes there are several factors, there are several things that may go wrong. Many projects don't get to financial close. So you don't want to buy land, invest so much in buying that large mass of land when you are not sure that the project will achieve financial close. And if it doesn't achieve financial close, what will you be doing with that land? Sometimes you buy the land in a remote area. So that's why you have an option agreement. The option agreement is just to provide that, okay, you're dedicating this land for me for an initial 5 years with the option to enter into a longer lease or to outrightly purchase it if the power project gets to financial close. So that's just for the option agreement. I mean, the other agreements you can just read them on your own. But I think we need to move to the next slide. Our time is almost, I can see that our time is almost over. Please proceed to the next slide. Yeah, still proceed to the next slide. Let me start looking at. Yeah, go on. Next slide, please. Go on. Go on. Go on. All right. So maybe I will just, yeah, I'm going into the power purchase agreement itself, to highlight the clauses and the parties that have obligations. So the primary obligation under a PPA or a power purchase agreement is for the seller to build, operate, and deliver energy to the seller. That's the primary obligation of the seller. Sorry, to build a power plant, operate the power plant, and deliver agreed energy to the buyer. That's the obligation of the seller or the producer. The buyer's obligation is to make payment. So that's the first obligation. The next obligation is security. What is the security that a seller needs to provide? A seller needs to provide performance security, while the buyer needs to provide payment security. So all of these are instruments. These are financial instruments that banks, that you can get banks or you can get a corporate guarantee to provide them. But essentially, it is a guarantee that on the part of the seller, he provides to show that he's able to perform the obligations. While for the buyer provides the security to be able to pay for the power. So for the seller, the term of the security may be short term, maybe from when you sign the agreement up to the construction stage. You want to have a performance guarantee to ensure that if he says that within 2 years, I'm going to build this power plant up to this capacity, then there should be a performance, guarantee that within this period, we will develop the power plant and it will reach commercial operations. Now, but once he now have the power plant, you are no longer interested in a performance security. It is the seller now that is interested in payment security. I want security to ensure that as I produce this power, right, you are able to take it and you are able to pay for it. And there are several clauses that you're going to see, take or pay obligations, deem energy obligations, all of that to ensure that now that I have spent these 2 years to invest maybe $100 million to build a 100 megawatts solar power farm, you should give me monthly, you should give me a security of maybe even 6 months payment security or 1 year payment security. It should always be available there so that as I run this plant, I'm going to incur I've already incurred costs that I need to pay lenders, I need to pay investors over a period of, let's say, 20 years. So because of that, I must receive payment every month for electricity based on invoice that I serve you. But if I issue invoice at the end of the month and you do not pay after a week or two, I should be able to go call on the payment security because I need the funding to be there, for me to meet my operational expenses and other costs. So that's you have provisions regarding payment security on the part of the buyer to ensure that the producer who is now operating the plant has, a pipeline, has a lifeline, has returns for all invoices that they pay. And that becomes even more critical for, let's say, thermal power plants who needs to always pay for the gas. You need to pay for the gas that is feeding your power plant. What happens if your invoice is not settled? You will have to go to you have to call on the payment security, in order to recover, to ensure that there is steady payment. The other clause there is the transmission, connection, provision, the arrangement with lenders, the licensing and permit obligations, the land, the insurance, issues of commissioning and decommissioning, because that has an impact in the environment. On the licensing, the primary obligation is on the seller. It's always the producer that should, or the seller that should have the obligation to procure the license that is required to produce that power. But there is no time, but there are practical situations. I even have one that I'm dealing with where the seller took on the obligation, to pay, to procure the license, especially if you are dealing with things like captive generation. If you are using a captive generation model, it will be the person buying. So under captive generation is when you are producing for your own use. So for example, a university is producing power. Instead of going to the utility to buy power, they want to have their own supply of power. But the university is not in the business of power generation. So they will need a power generating company to come and build the plant and operate it on their behalf. But because this plant is dedicated for them and is for their own use, they can get a captive permit, even though they don't produce it, but they will get the permits, so that at the back of that permit, the producer will come and build the power plant and then supply them with the electricity. Can we go to the next slide because of time? Then timing is also very important. The signature date will, most times it's not the effective date. Sometimes you have a signature date where only few clauses become effective and not the full agreement. Then you have the effective date. The effective date will usually be predicated upon the satisfaction of certain conditions. So those are CPs. So certain CPs must be satisfied. So sometimes you enter into an agreement, for example, you don't even have a license, right? So you will say that the producer should obtain a license within a certain period of time. So that would be a condition precedent to effectiveness. The agreement will clearly say that without the license, the agreement is not effective, right? So that's why you have, some of this timing that is different. Then, of course, there's also timing for the satisfaction of the CPs and financial close. So there will be specific timeline, for satisfaction of certain important condition precedents. Then there is time for testing to ascertain commercial operations date. So even when the plant is constructed, there must be a testing period to ensure that the plant is operating at capacity and is able to feed or to supply the power that is contracted. So there is a timeline provided for testing. There is timeline for interconnection. There is time for fuel supply connection to the plant. There is time, and you need that. That's also important. So sometimes you have a power plant, and at the back of it, you have the fuel supply agreement. So the fuel supply agreement, even though it is entered, the obligation will not kick off until a time within which that the power plant will be ready to receive the supply, So all those, that's also an important date. There are also cure periods. So sometimes you have, and that's especially a protection that lenders will require. So if a lender funds, a power plant, it will, and the producer has certain obligations that if they default on, the buyer can terminate the agreement. Now, that is a major risk for a lender, because if the agreement is terminated, it will not recover its investment. So because of that, you can have cure periods. cure periods, not just for the lender, but even for the producer, but more importantly for the render, so that the lender will say that, and that's where direct agreements. So there is, when we were looking at those agreements, there is what is called direct agreement. That was one of the agreements that after you sign a power purchase agreement, the lender may want to enter into a direct agreement with the buyer. So that agreement will provide, for example, that when there is a default on the part of producer, give me a time, allow me to step in. So those are step-in periods, for example. Let me step in and cure the default before, so that you don't proceed to terminate the agreement because of the investment that needs to be protected. So that's what cure periods are. And then important again, there are dispute resolution timelines. So you may have an agreement that has technical dispute resolutions. So you provide for timelines and the process for technical disputes. Then you have provision for other disputes, maybe arbitration, that are not technical, but that will take a longer period of time. So you may have expert determination for technical disputes, and you provide a timeline for them because they are sensitive and and you want to use, because of the time, for example, if invoice is disputed, you want that to be settled in good time. If there is a technical issue, right, you want any dispute around that to be resolved quickly. So you can inbuild timelines for that within the agreement. I don't know how much more we can go, but I think we can stop here and take any questions or comments. Not just questions, but in case you are familiar with the power purchase agreement and you want to provide comments, please feel free to go to provide comments. But I think I should pause at this time because we have just barely 2 minutes left. Thank you. So are there any questions or comments?
Good day, Sam. I have a question.
Yeah, go ahead. What's your name and can you briefly introduce yourself and then ask your question? Let me know you. Let me get to know you.
Yes, my name is Chidera Okoro. I'm an intern at the Lex Luthor Center, and currently I'm a 400-level law student at the University of Lagos.
All right, that's nice. Chidera, go on, ask your question.
Yes, sir. I believe I heard you say that states, according to the recent constitutional amendment, states are now the ones in charge of power generation for their states instead of, it's not like a federal power. I think I heard you say that, sir.
Yeah, go on and ask your question. Go on.
Yes. So my question is, if there's any situation in which the state does not have the competence or the funds for power generation within their states, is there any provision for the federal to step in that situation? Or has there been any situation similar to that as of yet?
All right, thank you. Thank you, Chidera. That's a good question. So, you see, the constitutional amendment in 2023, was followed, it threw a lot of things, right? That would have, the doctrine of covering the field, right? What we had at the time the Constitution was amended to allow states to, regulate electricity, you had the EPSRA, which is the Electric Power Sector Reform Act 2005. And that act essentially covers the field in terms of regulation of electricity. So, and based on the principle of covering the field, it meant that constitutional amendment will have become, it was, it needed to be seen how it will have operated with the old act, the EPSRA 2005. But the good thing was that shortly after, I think, in fact, that amendment, there was already the amendment process of that EPSRA that was going on, before the Constitution was amended. And so once the Constitution was amended, you then had a consequential amendment that was reflected in the Electricity Act. In any event, the Electricity Act was not even an amendment. It repealed the EPSRA 2005 and then enacted a new Electricity Act, right? That then provides for transitional provisions. And it is those transitional provisions that, are very critical, which I will briefly highlight. Now, before Chidera, the reality is that the Constitution had always provided that states can generate electricity. The only problem that led to confusion was that it says that the states should not generate electricity in areas covered by the grid. And the question is that, is there any area in Nigeria that is not covered by the grid? Yes, there are. There are actually a number of areas that are not covered by the grid, but most of the areas that can be bankable, that have commercial activity, were covered by the grid. So the Constitutional Amendment then took out that qualifier and just allowed states to generate. Then what did the Electricity Act say? The Electricity Act now says that once a state enacts a law, establishes a regulator, and operationalizes that regulator, then the regulation, now, so what we are dealing with is regulation, not generation. And that's why I said you should ask your question so I don't interrupt your flow. The reality is that it is not expected that states will start generating electricity. What they are to do is to regulate and then provide the incentive and the environment for investors and private players to come and generate electricity and do business in their states. So, and the Electricity Act acknowledges that. I am in the school of thought that believe that distribution and supply of electricity to end users should not be the business of the central government. In other words, it should not be regulated at the central level. So let me give you an example. In Lagos, where you are, right? Maybe, okay, you're in the university, but just maybe when you go outside the university, you have different businesses that get electricity from Ikeja Disco. I guess Unilag will be getting their power from from Ikeja Disco. And then maybe a business center, wants electricity and it goes to Ikeja Disco. And that arrangement, the purchase of electricity by a business center outside Unilag, right, is being regulated by NERC in Abuja. I don't think that was a proper framework. So if the business center if there is an issue of electricity theft, issues of even metering, right? Metering that customer, for me, it is better regulated by the state government than from Abuja. If that customer has a problem with billing, he will start writing petition to Abuja from Lagos as a business center. It's easier for them to, if there is a state regulator in Ikeja there, around Alausa or wherever, they go there and make their complaint. So the summary of my answer to you is that what it effectively does is that the supply, that chain of supply and distribution, is now managed by the states. It's not generation that is to be managed by the states. It is the regulation for that supply and distribution of electricity to end users at the back end that should strictly be the business of states. And what it says is that if there are states, so you have some utilities like in Abuja Disco right now, it transits Abuja. It supplies electricity to the FCT, to Nasarawa State, to Niger State, and to Kogi State. So you can imagine that if there is a problem in Lokoja or Ayimba or Ida in Kogi State, it is the MD of Abuja Disco in Maitama, Abuja, or sorry, Zone 4 in Abuja, that is supposed to be in charge of that. So what it says is that if Kogi states now have their own regulator and they're able to operationalize it, NAC will cede the regulation of electricity to that regulator within the states. It doesn't delve into generation. It's not primarily the issue of generation, it's the issue of regulation. And to your last question, which is practical, how has the experience been? We'll wait to see how it will flow. You know, the law was just enacted last year. I think about 4 or 5 states have transitioned to this state electricity market. It is yet to be seen how that will go. But I think what is important is for the states to ensure that it works. There should be a synergy. Know that there is a committee that has NAC and the other states governments, right, to ensure that it works. So there will certainly be challenges, but the idea is to ensure that it works so that the states are empowered to regulate at least that value chain, that level of electricity. It's easier for a state to, you know, make arrangements for electricity theft, you know, to be stopped in the state than for Abuja to be policing electricity theft, for example, in the backyards of state government. I don't know, Chidera, if that clarifies your question. Hello, can you hear me?
I have a question, sir.
Okay, please proceed with your question.
Thank you so much for that clarifying.
Thank you, sir. I wanted to ask, I know that the policy of the government in recent years is that of ensuring competition within the industry.
Sorry, you didn't introduce yourself. Sorry to interrupt you. Can you briefly?
Sir, I am Franklin Chisom Ebere, and I am an intern at Lex Data Center, and I'm also a 300 level officer at Ahmadu Bello University.
Oh, that's nice. Okay, go on.
Yes, I was just saying that even though there is the drive of the government to increase competition within the market, we see that the power purchase agreement is very specialized and has a lot of specific clauses which can vary. But just to provide level playing grounds and uniformity within the market, do you think the industry might benefit from a standardized PPA, just maybe to reduce transaction costs and improve efficiency there? And then the second question relates to what you mentioned, the innovations by the recent constitutional amendment and the consequent amendments of the Nigerian Electricity Act too. And I just wanted to know, assuming I was generating power up to the required amount that would warrant regulation, but I wasn't connecting it to the grid. For instance, generating power just to supply my local government, which definitely would be enough for regulation, but I was not connecting it to the national grid. Can I make an arrangement such that it's like a private contract to the end consumers themselves, the end users?
Yeah, so your questions are very, very important questions. Let me answer the last one. So although our discussion was more of grid, related to grid electricity, there is a large market that is growing in Nigeria. And I think that's where a lot of activities will even, you know, we'll see more activities in it, you know, in the coming years, is off-grid electricity market. So what you are talking about, you know, supplying electricity to your market, to your local government, is off-grid solution. So yes, you can have that, but it is still licensed. Once it reaches 1 megawatt, right, you will need a license, but it will be an off-grid generation license. That's what you will need in order to do that. Now, to your first question, I'm not sure about a standardized power purchase agreement. You see, every state has its own peculiarity, and the idea is that when you standardize, when you make rules, for all, for all parties, you may not achieve. You should allow parties. So, for example, part of the disincentive for investments was the tariff structure, when you had a uniform tariff across all agreements. And many investors say that this tariff cannot work for us. So the whole idea is that you should leave it for states. If people in VI, for example, are happy to have, to pay higher for electricity than what you have in maybe people in other places, then you should give them that freedom, right? To be able to enter into agreements that work for them. Willing buyer and willing seller agreements. Now, there are certain boilerplate clauses that will always be there. There are certain principles that are also, the same, right? But you may not have, you are not going to, is unlikely to have a standard agreement that fits, one cap that fits all. No, the whole idea is, let's allow parties to enter into agreements on a willing buyer, willing seller basis, provided the fundamentals, are contained in the agreement.
Thank you, sir.
You're welcome. All right.
Please, we have 2 questions in the chat box.
Okay.
So the first question is from Ms. Oluwatofumi Ajayi, a 400 level student at Bowen University. And her question is, what is the level of difficulty associated with the PPA approval process in Nigeria? Is the process seamless or somewhat cumbersome?
Okay, so if you are dealing with off-grid power, it's not cumbersome. But if you are dealing with power to the grid, I wouldn't say it's cumbersome, but there are other issues that come to play, right? So, for example, it is not the producer and the buyer that own the grid. So you are going to have time negotiating the grid connection agreement. And even if you go to if you go to NERC for a license, they will want to ensure that all the relevant players and key actors, are aligned before they approve or they give you license. In the strict sense of it, the PPA is not what is being approved. It is the license that is being to be granted that is the issue. So the parties enter into an agreement, the PPA. Once, if it is in the grid, of course, you will have to comply with all the regulations in the, in terms of your tariff structure and other things. But the PPA itself is an agreement between the parties. It is the license and the other things that you need to get for the agreement to become bankable that is the issue. So let me give you an example again, just a practical example. When we talked about renewable source of energy, I mentioned that 85% of our energy is from thermal sources. The remaining 15% is from renewable sources, but the renewable is only hydro. So the Shiroro Dam, the Kainji Dam, the Jeba, all those power, the hydro plants, right? They are the ones that are giving you the 15%. The other renewables, like you don't have a wind or a solar power plant that is feeding the grid. And if you know the issues around energy transition, part of our energy transition plans is for the grid to have like 30% of our power coming from solar power plant, because to the environment, you have a lot of solar energy that is being wasted. And if you add that to your mix, to your energy mix, it will reduce the impact of, of fossil fuel to the environment. Now, since 2015, MBET initial 14 PPAs. Those PPAs are supposed to be the first solar utility scale PPAs that will feed into the grid. But the PPA was never executed. And the issues are the macroeconomic, they are the financial issues, the investors we are looking for, there's what we call put and call option. And they want a put and call option, and they want the put and call option to be dollarized, to be in dollars. So put and call option is an option that allows the investor to, if there are issues, right, to just leave the plant and the government will have to pay for it. So it will exercise its put option. And it also gives the government the right to exercise a call option, to call for the power plant. So the producer would then surrender the plant to the government. And then there is already a calculation on how much for each year the government should pay. And that calculation, because of the inflation and other things, needs to be in dollars, right? And also certain payments, capacity payments, need to be made in dollars. Now, the government wasn't able to do that with what happened in Gurara. And, with the dollar scarcity, the government said it doesn't have the dollars to make, those payments. So because of that, those PPAs, so I said 2015, it's already 9 years. Nobody has signed those PPAs. And the MBET, in fact, it has lost its license. So those are some of the issues, that will impact on a PPA. However, for off-grid, right, you won't have that problem. I've negotiated several off-grid power purchase agreement. There is somebody, maybe just a particular store, a particular estate, a particular factory, they need power. It's just between the parties. You negotiate it. Once you have your license, you negotiate it and you enter into your agreement. But for the ones that have to do with the grid, there are larger, issues and, policy government issues that are affecting the turnaround for those power purchase agreements. Now, what's the last question? Can you quickly read the last question? Let me get to it.
Sorry, sir. So I made a mistake. We actually have 4 more questions.
Okay, do we have time? If we have the time for it, you can quickly, and
Yes,
I'll also
please.
try to be brief in answering that.
Yes, please. The next question is from Rebecca Olatimu, a 300 level student at Babcock University. Her question is, what is the most effective method of dispute resolution for power purchase agreements? And what is the impact of PPAs on energy prices for consumers and end users?
Yeah, dispute resolution. I had mentioned that you should have expert determination. I would recommend expert determination for technical and financial disputes. Then you should have an arbitration clause for other legal and non-technical disputes. So that's what I would recommend, and that's what you see in many of the big power purchase agreements. Sorry, what's the second question?
The second question is, what is the impact of PPAs on energy prices for consumers and end users?
Okay, so the PPA mirrors the tariff. So it's not the PPA that impacts on tariffs. So if you are negotiating a PPA that is regulated by the tariff, there is a tariff regulation that is set by the regulator. That's why we determine the tariff that will be set in the power purchase agreement. But if it is not If it is not regulated, then it will be based on willing buyer and willing seller. You know, it will be based on willing buyer and willing seller arrangement. But ultimately, the amount that they are selling the PPA, that they are selling power under the PPA, will affect the tariff, in the sense that the tariff is supposed to be able to be enough for the power to be purchased. You know, that's part of the challenges that you have. If the tariff cannot take care of ultimately the tariff is supposed to pay for all the liabilities across the value chain. And if it doesn't, then it's a problem. But ultimately, right, the summary is that the tariff is a different issue. Tariff is either, if there is a regulation for it, it is the regulator that sets the tariff. But if there is no regulation, it is going to be a willing buyer and willing seller arrangement.
Thank you, sir. Please, the next question is from Susanna Oladejo, and her question is, in a case where a lender finances a transaction, does that give them a right in the transaction?
Yeah, so they will have, lenders will require a lot of protection and the rights, but the rights will usually be triggered in the event of default, right? So if it goes well and this buyer is paying for the electricity and the seller is able to pay for its operational costs and to pay the lenders will not bother interfering. But where there is an event of default that will affect the ability of the seller to pay for the loans, that's where you have things like the step-in rights. The lenders will exercise their step-in rights to take over, you know, some of the obligations of the seller. And that's why you have, you know, some of the agreements we talked about, like the direct agreement, like even the put and call option agreement. So the put and call option, sometimes it may not be the producer that will exercise it. It may be a lender that will trigger the put option or the call option, as the case may be. So usually in the event of default, yes, the lenders will exercise their rights to ensure that their financing is protected.
The next question we have is from Catherine Opadokun, and her question is concerning other essentials a lender will look out for in a power purchase agreement. She also further noted that you mentioned direct agreements. What specific agreements protect the lender from future liability?
So there are several terms, you know, all those terms that I highlighted. You know, there are terms that I didn't highlight in this presentation, but the ones I highlighted are essentially the ones that lenders will be looking into, including, you know, terms like the term of the agreement itself. So PPAs are usually long-term because of the investment, it will require a long time for the loan to be repaid. So if you have a PPA of 5 years and you're looking for 100 million, you know, that will not, you know, fit into the lenders. You know, the lender may find that to be risky. So you want the contract to be a long-term contract. You want to have liquidated damages for performance. You want to have, you know, provisions that deal with timelines, provisions on the tariff, on payment, on invoicing, on force majeure, on the change in law. So a number of provisions, right? Even the dispute resolution mechanism, lenders will look at all, you know, those terms. Then I think the other question was what was the other? Yeah, the documents. So apart from the direct agreement, so the direct agreement is the agreement that the lender enters with the buyer. And you know why it is a direct agreement is because the lender is not providing the financing to the buyer. It's providing the financing for the producer or the seller to build the power plant. So the main financing agreement will be between the there are financing documents, the loan agreements, and the share sale, share charge, will be a share charge agreement, security documents, and the financing documents. All of the financing documents will be there, but it will be between the lender and the seller, because it is the seller that needs the loan for the project. Why I mentioned the direct agreement is because of those rights that the lender wants to exercise. The principle of privity of contracts would have prevented them from exercising those rights because there is no privity of contract between them and the buyer. So that's why they enter into that direct agreement where the buyer acknowledges all of the protections that the lender is entitled to in the event of default, so that if they want to appoint a receiver, the buyer should support them in the appointment of the receiver. If you see some of the transactions in Nigeria, I think Kaduna Disco currently, I think is under receivership. Ibadan Disco too, I think is under receivership. So the lenders will appoint their receiver. I think Abuja Disco was also under receivership at some point before the lenders then sold it. So you want to have all the the lender will want that needs that direct agreement so that the buyer supports it in its enforcement action in the event of default. Do we still have questions?
So, yes, thank you very much. That was the last question. And on behalf of the Lex Data Center, I would like to say thank you very much for taking time off your busy schedule to give us this very insightful presentation. We hope that you come again to give us a presentation on another topic. But before we finally close, we'd like to hear a few short closing remarks from our Executive Director, Dr. Wole Konuji.
Thank you very much, Cephas. That was a very brilliant presentation, and I believe that our interns have learned a lot from that presentation. This goes back to what I've been telling our interns in our private discussions, that they need to get familiar with agreements, because as lawyers, the bulk of what they'll be doing will be, drafting agreements or advising on agreements and all of that. So I remember that my, first few weeks in Aluko Anoyibo, I spent that working on the gas purchase agreement. Some of these things are very technical, but as you go on, you tend to get a better hang of it. So thank you very much, Cephas. That was a very wonderful one. For our interns, I know that some of the things discussed may, sound a little bit very technical to you. We'll make the slides available to you after this event so that you can go and do your further research on these things. So once again, thank you to all those that have attended this session, and we believe that when we invite you to attend other sessions in future, you would find the time to make yourself available. We've come to the end of this event. Do have a wonderful evening, everyone. Thank you.
Thank you, Doctor. Thanks, everyone. Bye.
Yes. Yeah, bye.